Hello, and welcome to Raising the Bar with the MBBA. I'm your co-host, Adiola Adejobi.
And I'm Jason Clark, president of the Metropolitan Black Bar Association. For those of you who aren't familiar with the organization, the MBBA is the largest association of predominantly African-American attorneys in New York. Our mission is to advance equality in the pursuit of justice, assist in the professional development of our members, and address legal issues affecting New Yorkers.
The goal of Raising the Bar with the MBBA is to foster a substantive conversation about justice issues in our community and to try to identify a couple of solutions in the process.
Today, we're talking about prenuptial agreements.
Joining us today are attorneys Morgan Mouche and Dilpreet Rai.
Thank you so much for having us.
Thank you both for joining us and being here today. So prenuptial agreements, what are they? Who gets them? And what can they do?
Generally, a prenuptial agreement is a contract between spouses or prospective spouses, which deals with what will happen when you die, what happens to your separate property, the property that you acquired during the marriage, and also, in the worst case scenario, what happens in the event of a divorce. There are many different ways you can structure a prenup and different things you can address, but big picture, it's a contract that you negotiate before you get married that addresses a lot of the financial considerations during the marriage. And basically, big picture, you want to understand the law of where you live and how you may want to deviate from that law in terms of what you want to address during your marriage.
And I would add that there's a spectrum of what your prenuptial agreement can look like. But under New York law, essentially you can start with a prenuptial agreement that essentially mimics what the law is in New York. And you may ask, why would someone want to do that if the law already protects them? Sometimes it just gives people that added protection to know that they had those conversations before they got married, and they have a document that sort of memorializes those conversations that they had. And on the other end of the spectrum, you can have a prenuptial agreement that completely flips the law on its head and deviates in every way. So one of the first or the threshold questions you need to ask is, what is the law in the area or in the state that we plan to get married in or reside in? And the question of which state you look to in drafting your prenuptial agreement is really a threshold question. So in New York State, once you get married, everything that you acquire during the marriage, with few exceptions, for example, inheritance, is marital property. And that includes debt. Any debt you acquire in either party's name is marital property. So if you are going to flip that on its head, then you might want a prenup on that end of the spectrum that basically says it's as if a marriage doesn't financially exist. And so everything that I had before the marriage and everything I acquired during the marriage remains my separate property. And there's lots of things in between and lots of deviations or variations from those types of prenuptial agreements.
Now, when it comes to prenups, it seems to be something that's very contentious, right before someone gets married. I know you talked about like different state laws and things like that. I guess this might be like a conflict of laws thing, but like, let's say someone gets married in California, if you will, but then they're married for, let's call it 20 years, and during those 20 years, they actually resided in New York City, right? How would that, I mean, obviously you have a prenup to kind of forego having to deal with the courts on that issue, but generally how would that play out?
So as Dilly said, the question of what law should be included in the prenup is a threshold question you have to address before you actually get married. So the initial definition, I guess we should back up for a minute. So to say a prenuptial agreement is a contract that you have to sign before you're married. If you actually execute the document after you're married, it's what's called a postnuptial agreement, which requires different legal consideration, meaning it has a different threshold requirement for what you would have to offer to your spouse or what you would be willing to accept to make it an enforceable contract. So the first thing, big picture, is if you want a prenuptial agreement, you have to make sure you sign the document before your wedding. You cannot negotiate the terms of the agreement, get married, and then sign it, because the circumstances have now legally changed. So in your example, if a party has a prenuptial agreement in California because they were residing in California, and then they move during the marriage to another state, in their prenuptial agreement, they should have, in most almost all of them do, address that the law of the prenuptial agreement moves with them wherever they move. Because a big reason why anyone would get a prenuptial agreement is to have clarity as to what is going to happen with your assets, what is your financial understanding during the marriage. So when you know, in California, we got married in California, we resided in California, we negotiated a California prenup. And no matter where we move in the United States or around the world, even though the divorce laws may be very different where you end up living, the laws of California are going to apply under the terms of your agreement. If you don't have that provision in your agreement, you could run into an issue about where you end up getting divorced. But the vast majority of documents and a well-drafted document would ensure that the law of where you actually negotiate the prenup moves with you wherever you move.
And so in terms of getting a little bit more granular about the prenup itself, what are some of the things that, from your practice and experience that, one, you think people should always include? And what are some of the things that maybe people forget to include and they end up becoming really contentious?
A prenuptial agreement typically has 3 to 4 parts, and you can expand it or you can limit it from that. But typically you're going to see a section that defines what is separate property and what is marital property. So without a prenuptial agreement, the definitions that apply are the definitions in whichever state's domestic relations law. And so the very first component is going to be, what do we want to be marital property? Do we want marital property to be everything that each of us acquire during the marriage, regardless of how title is held? Or do we want marital property to be more limited and restricted to only bank accounts that we put into joint name, or only homes that we acquire in joint name? So that's the very first component, is what do we want the parameters or the definition to be of what is marital property? The corollary to that is, well, what do we want separate property to be? And so if you have a very detailed or a comprehensive marital property regime, then you might have a very limited separate property definition section, or the inverse. The other component is what happens in the event of what we call a termination of the marriage. So we call it a triggering event, a termination event, whatever you would like to define it as. What happens in that case? How are those assets that we have determined to be marital under the definition that we have provided, how are those going to be divided upon a marriage, upon a divorce? And then the other component is, what about support? Are we going to talk about spousal support in this prenuptial agreement or not? Are we going to say we'll determine it if and when at the time of a termination event, or are we going to say, no, we want to talk about it now, we want to waive it because we both intend to be fully supporting ourselves now and in the future? Or are we going to have some sort of carve out in the event one of us stays home to be a primary caregiver for children or another dependent? And then finally, it's the last component I would say is what happens in the event of death. Perfectly happy, intact marriage, but a party dies during the marriage. What happens in those circumstances? Particularly if you've created a lot of separate property. For example, the house in which you reside is someone's separate property. What happens when that person who owns that home passes away? Will you be able to remain in that home if it's in your spouse's name and it passes to your spouse's estate?
So that's interesting. I mean, one thing that I think people don't always realize, and this kind of goes to what Morgan, you were saying in the beginning, when you're thinking maybe you're just signing a prenup or trying to do that like the day before your wedding. It's usually a lengthy process to be able to get all this done. And I imagine if you don't go through that process, there may be a concern that whatever it is you sign may not be actually held as enforceable and valid. So can you talk to us a little bit about, some of the costs of having a prenuptial agreement and just, what the process is like? Let's say two parties say, yes, I want to do this. Like, what should they expect?
Absolutely. So usually there's one person who really would like the prenuptial agreement. And that person should speak to an attorney sooner rather than later. Ideally, you would speak to an attorney before you actually get engaged. That's really the ideal scenario. But once you're engaged, reach out to an attorney so that you can begin to understand what New York law, and I'm going to speak about New York law because I practice in New York, and the show is in New York for New Yorkers, what New York law actually provides. If New York law protects you in a way that you're comfortable with, then you may not need a prenup. Because as you said, it can be a very stressful, contentious process. You're in the midst of planning your wedding, which is a joyful event, and you have to deal with this. And so the benchmarks for a less stressful process would be to educate yourself sooner rather than later. So you understand what New York law says, what you're comfortable with, and what you would want your document to provide. And to come to an agreement that your prospective spouse is going to be willing to sign, you need to have some very serious conversations with your soon-to-be spouse about how the two of you intend to live during your marriage. That's really what a prenup forces in every relationship that gets one or talks about one, is you have to have those conversations about what are your expectations during the marriage. Do you expect that even though you're living in an apartment that was purchased by one of the spouses before the marriage, that you would share in the value of that apartment, even though you're not titled and you didn't actually contribute to the purchase, but maybe you've helped renovate that apartment so you feel as though you've helped increase the value? Do you intend to never waive your right to spousal support because you're someone who anticipates wanting to stay home when you have a family? Are you someone who earns less money than the other spouse, or you're someone who earns more and you want to protect some portion of that income because you've worked a long time before you met your spouse and you want to preserve some of that value? These are all things that people think about and they may be afraid to say to their spouse, but you have to have those conversations. And ultimately, even if you decide that a prenuptial agreement isn't right for you, because not everyone needs a prenup, you don't have to be wealthy to have a prenup, but you do have to have an understanding of what will happen during your marriage and whether or not you're comfortable with that, and whether it's worth it to you to have these difficult conversations with your prospective spouse, ones where people are often very upset, there's usually tears, and you really have to understand what you're asking. And as a matrimonial attorney, and I'm sure Dilly would agree, and we're both married, so we know what that life is like. Yes, I do have a great husband.
I've got a great husband.
He does too. You know, marriage is a partnership, and New York State views marriage as a financial partnership, and that's the real basis of why New York State divides marital assets and doesn't say one of you leaves the house to go earn a living, so you get all of the assets and the other person doesn't, whether or not you have children. So talking through how you envision that partnership with your spouse, your prospective spouse, is crucial. And you also mentioned someone brings a prenup to your door, you know, here, sign this, and it's just a few days before your wedding. We absolutely do not recommend doing that. You do run the risk of having an agreement that could be invalidated. That's only one way that an agreement can be subject to attack. And while the law doesn't say that just because you were offered the prenup right before the wedding, that by itself is enough to invalidate it, under those circumstances, there are other things that would not have happened. So for example, in New York, you're required to have financial disclosure in the negotiation of your prenuptial agreement. So that means even if you don't know what the other person has, you have to provide disclosure of your assets and liabilities. Some states have a much more onerous, a much more in-depth requirement where you have to give, tax returns and things like that. We recommend that you do that if you want to make sure that your document will be enforceable. But there must be knowing waiver of the rights that someone is waiving in your agreement. So if they think that you are only worth X dollars, but you are really worth multiple times of that, and they would not have necessarily agreed to the deal that you gave them in the prenuptial agreement had they known that, a New York court can, at the back end, invalidate your prenuptial agreement.
Can you talk a little bit about maybe like the imbalance of power potentially during the negotiation? So let's say the party with more money has an attorney and the other person doesn't have an attorney, how would New York law or the courts maybe interpret that in terms of that prenup being invalidated?
To back up a little bit, I just think that there is a little bit of a stigma that we need to move away from with prenuptial agreements. And the idea is that, by asking for one, you're sort of jinxing your marriage or you're expecting your marriage to fail. And I think it's important that just like if you were to move in with a roommate, you would have conversations, or start a new business with someone, a financial enterprise, you would have conversations about how expenses are going to be paid, how capital is going to be contributed to your business, how are you going to sort of divvy up the tasks, or what are your expectations in the event a partner dies in terms of what happens to the business. So I think that we need to sort of break down the stigma with respect to prenuptial agreements and really look at it as just another thing for individuals to know what they're getting into, to understand that a marriage is a romantic enterprise, but it's also a financial partnership. And that's how the state looks at it, that's how courts look at it. And so if you're entering to a marriage like that, then you probably want to know what kind of rights come with that and expectations come with that. So if you take a step back and look at it from that perspective, then this concept of an imbalance of power kind of sort of shifts away, because both parties in that situation have power, because they're both educating themselves in terms of what rights they might have in the event of this union that they're creating, right? But I think that there are some things that you can really do to protect yourself, because the whole point of entering a prenup is to give some sort of finality or certainty as you enter this union together. And so you don't want to enter a prenup that ultimately is going to be thrown out, the door, right? So making sure that you both have attorneys is really important. Because it's important to recite that in the agreement, that they both had the opportunity to speak with an attorney, review the agreement with an attorney, because that's going to ultimately help you in being able to enforce it down the road. So all the work that went into doing it is going to mean something down the road. I think also language is something to make sure that we consider. I've had situations where someone is marrying someone from another country or English is not their primary language. It's really important to give yourself enough time to make sure that document is appropriately translated, or that an attorney is hired that has the ability to translate it appropriately for the person who's not the non-English speaker. Or if you get married overseas and enter into an overseas agreement that you want to have enforced in New York one day down the road, it's important that that language barrier was removed and the person was able to knowingly and willingly execute the document. And so there are ways to be able to adjust the balance, but you have to be willing to walk away from getting married. And whatever the wealth is in the picture and the equation, whoever's willing to walk away and not actually get married, and I don't mean walk away from the relationship, because you can still maintain the relationship and not undertake the union, the financial sort of contract that you're entering into by getting married. But it's important to understand that that's always an option, and the person who's able to do that maybe ultimately has the greatest leverage in the negotiation.
Because that actually, and you may have already answered it, but one of the questions I had as you were speaking is, let's say there are two parties, they want to enter into a prenuptial agreement. One party feels very strongly about one of the components of it, whether it's whichever of those four that you were mentioning before, and another person has a very different view on whatever that issue is. How do people, how does that usually play out? I don't want to take words here. It certainly sounds like at some points you just have to be ready to walk away from it. But, just in your experience, how does that, usually transpire?
So, for example, it's really a negotiation process. So just like any other contested negotiation between attorneys representing their clients, what's most important to your client and where there's maybe some give. Mm-hmm. And so in the negotiation, if one person says, I refuse to accept a waiver of spousal support because I make so much less money and I think I'm going to stay home with children and I don't believe it's fair. And you can't come to a resolution with respect to that point. You may offer something in exchange. You may say, well, we will guarantee that there's a home that you will live in. There are many ways to craft an agreement to address people's concerns, but it all is within the parameters of what the two parties are comfortable with. So there are certainly places in the negotiation where you'll just reach a standstill And often, as Ms. Rai said, the person who says, I'm not going to give any more on this, just like in any other negotiation, then there's going to be a decision point, right? And it will be, is there somewhere else you can get some comfort? Somewhere else you can get something more? And will that satisfy you? And if the answer is no, then in some extreme cases, the parties don't end up getting married. But in reality, in most cases, they do. But that's really between the parties and not so much between the lawyers. We try to get to the solution by offering creative options. But as you said, there's usually one person who's willing to draw a line, and that person, when it comes down to it, may have to say that.
Yeah, so like when Mariah Carey got $5 million for waste of time, they agreed to that. They agreed to that, right? So, she got her money.
Right. And on that point, with respect to for example, for engagement rings, just as an aside on this conversation, an engagement ring is a gift in contemplation of a marriage. So if you are engaged, but you end up not actually getting married, you have a right to get your engagement back. However, your engagement ring back. However, if you give your engagement ring on a holiday, or you make it clear that this is a gift, you could have some issue with that. So,
So
make sure you, I don't know. Wait till right, I'm sorry, maybe on the 13th. But
Maybe avoid that.
So previously, you all were talking about how within the prenup you can contemplate things around debt. Can you talk a little bit more about that? Can you flesh it out a little bit more?
In addition to when you get married, it's not only the assets that you acquire that become marital property under New York law, it's also any debt you acquire. So that could be credit card debt, student loans, mortgages, everything. Anything that you take out in your name as a married person, technically the other spouse, it is considered a marital debt. It's not necessarily the case with respect to the creditor, but it is when it comes to division of assets and debts upon divorce. Okay, so sometimes I do have clients who come to me because they have concerns about a spouse's spending habits. And they want to make sure that they're protected. And so they may not have a lot of wealth, but they still are looking for a prenuptial agreement to try to address that and to make sure that debts acquired in one person's name are carved out of what is considered marital assets, marital debt. Or they may have debt that they're bringing into the marriage, credit card debt or student loan debts, and they want to make sure that it's very clear that those liabilities are not going to follow into the marriage with the other spouse. And so they will make sure that they specify that any debts prior to marriage, just like any assets acquired prior to marriage, are separate debts that the other spouse, by getting married, is not assuming any responsibility for. And so we oftentimes, I've had young people come to me who have a lot of student loan debt and who are interested in protecting their spouse from that type of student loan debt. And so they want to make sure that that's carved out and specifically noted that even if I contribute as a married person to my spouse's student loan debt, that it does not become my debt. And I have no responsibility for it upon divorce. The other side of that is what happens if you make payments from marital assets to student loans, premarital student loans during a marriage. A case law in New York permits the possibility of credits back if you use marital property to pay separate property debts. So sometimes I will have provisions that say, in the event we do use marital property, meaning our income that we acquire during our marriage is marital, if we use it to pay someone's separate property debt, can I get a credit back in the event of a termination? And sometimes people don't want to go back years and years and do bookkeeping and figuring out how much did I pay to my spouse's student loan and should I get a credit for that? So we will often say, in the event they choose to use marital money, no one's going to come and seek a credit. So there's certainty and finality in that and some protection there.
And just to be clear on debt, so while you can also agree that during the marriage, debts that the one party incurs is not going to be considered marital debt. So if one person is a spender and they have constant credit card debt, and you've agreed in your prenup that individual credit card debt will not be marital debt, then that makes it clear to one person, okay, in the event of a divorce, we are not going to have to pay from our marital assets the credit card debt that you have incurred. This is a simplification because obviously you can anticipate that someone may incur credit card debt on behalf of their family, on behalf of their, to use for their own living expenses or for children's expenses. And in the event of a divorce, it may not be equitable for them to shoulder that entire burden themselves. So there are ways to address that in the specifics of your document, but they're just things that people can think about what they may want to address.
So two people have decided they're going to get their prenuptial agreement. They get married. Congratulations to them. But at some point they decide that they want to change it. They maybe want to modify it. Or let's say later on as they're going on with their life, they end up, one of the parties drafts a will. How does, can you change the prenuptial agreement later on if both parties agree to it? And the second part is, are there other documents or other things that can actually affect the validity of the prenuptial agreement?
So I'll take the first part of that question. So yes, you can amend your prenuptial agreement, but it is no longer a prenuptial agreement, it is now a postnuptial agreement. Because no one has any right, your spouse does not have any right to your assets or to the income that you're earning before you get married. So a prenuptial agreement requires, just like any other contract, an exchange of rights, what's called legal consideration for the bargain that you're making. I'm giving up my right to this in exchange for that. But before you get married, you haven't actually been granted any rights. You're just two people who love each other, who decided to get married, and you're not allowed to go and withdraw money from that person's account. You don't have any right. But once you're legally married, with or without a prenup, certain rights have inured to you as a married person under the laws of the state of New York. So if you do not have a prenuptial agreement, you have already had, the rights have vested in you already. So for you to then waive those rights, you're required something more in your bargain, because before your marriage, you had no rights. And then after you were married, you did have the rights. So in the negotiation of an amendment to a prenup or in a postnuptial agreement, what your lawyers will explain to you is, you may have wanted to say beforehand, what's mine is mine, what's yours is yours, be done. There really won't be very much marital property to divide. We're each going to be responsible for ourselves. After you're married, there are rights that your spouse has now been granted in the property that you have and the property that you will have. So you have to offer them potentially more in order to make that negotiation. But we encourage people to consider whether they need to or want to amend their prenuptial agreements, because you can imagine that at the beginning of your marriage, no one has a crystal ball. No one knows how successful someone may continue to be or become. Someone may assume that they're going to have this business that's wildly successful, and maybe it isn't quite as successful. Maybe they have more children than they anticipated, and maybe there's a life event that was unanticipated, and now you really need to make a more fair or equitable negotiated deal between the two of you so that you both feel comfortable. And so you certainly can do that, but legally, your lawyer will have to explain and you'll have to talk through how to effectively do that to ensure that the document is enforceable.
And it's important that it's executed, any amendment needs to be executed with the same formality as the original prenuptial agreement was executed. So if it was witnessed and acknowledged by a notary and signed, it needs to be done in the same way. You can't just write it on a napkin and say this is an amendment. It doesn't work. So it's really important that if you can amend it, but it's important that you seek legal counsel to do that, because if you already have an agreement and you're amending it, then there's a lot of complications that really need to be fully thought out.
All right, and so we're out of time. Thank you so much for all of this very valuable information. We want to thank you for watching Raising the Bar with the MBBA on the Manhattan Neighborhood Network.
See you next time.